As we all know, we lost really a great Supreme Court justice earlier this year. And Justice Scalia is a model for what we want in the future and someone whom we'd like to replace. And I'm just going to go over a few of his cases and tell you a little bit about him. I've been a very lucky person, and I've been lucky enough to go to the Supreme Court a few times, never to argue or anything. Actually, it was for parties. And one was Justice Brennan's birthday party. And another time was for another party for another justice, and I met Justice Scalia at a small group discussion on separation of powers, and so I just feel very honored. When I met him, I said, well, you know, I have been saving the picture I took of your name over your parking space at the Supreme Court. I saw that when I was at Justice Brennan's party. And he says, well, they took those away from us because they said that that was a gift that wasn't on the books because we didn't have to pay for parking. So he says, now we just have to park like everybody else. So I thought, okay, you're cool. But anyway, so this fellow is probably one of the most intelligent and qualified people that have ever been on the Supreme Court. And he was an attorney, he was a judge, he was a professor. He had it all before he was appointed to the Supreme Court by Ronald Reagan. He was confirmed 98-0. Practically unheard of course, these days. Now, this fellow may be awfully smart, but my husband, Dan Brown, not the famous author, has bragging rights. When he met Justice Scalia, Justice Scalia actually asked his advice on something. Dan, of course, won't tell everybody what the advice was, and it was like, should we have a coffee break now, or should we wait till after the next little talk? So during all this education, everything he's done, Justice Scalia managed to have 9 children and had the same wife, of course, through all these years. And his contribution to the court was that he was an originalist, meaning the Constitution says what it means. He had a commitment to limited government and separation of powers. So he really objected to the court making law, which is what we see now and are so upset with. He says, you don't need a constitution to keep things up to date. All you need is a legislature and a ballot box. Persuade your fellow citizens that something is a good idea and pass a law. That's what democracy is all about. But don't be mistaken. He wasn't just an unpleasant old grouch. He really loved to have a good time. This is him as a grand marshal in an Italian parade. And let's see, here we are, me there at a little cocktail party. One of the things that made his opinion so memorable is that he not only talked through the Constitution, he did it in such a clever way that it made people pay attention. Now, his big thing was words say what they mean. Now, this man loved to fish. And so one of the cases I'll tell you about is demonstrating how he was it was a case where there was a statute that had to define whether a fish was a tangible object. Now, here he wrote a dissent with Justice Thomas and Kagan. And one of the things I'll tell you with these cases, and which is very interesting and you'll find interesting, is who joined in these opinions. It's not what you might think. Well, the court had found that a fish was not a tangible object. In Scalia's defense, he said, the case raises the question whether the term tangible object means the same thing as the statute says in everyday language, any object capable of being touched. The answer should be easy, yes. The ordinary meaning of tangible object is a discrete thing that possesses physical form. A fish, of course, is a discrete thing that possesses physical form. See generally Dr. Seuss, one fish, two fish, red fish, blue fish, 1960. So he made people read what he wrote. Now, on to more serious things. The first case in which we talk about a huge medical issue, and Justice Scalia was involved here, is the right to die. Excuse me. And this is Cruzon versus the director of the Missouri Department of Health. Nancy Cruzon was in a persistent vegetative state after an auto accident. She was in a state hospital, and the state bore the cost of her care, which is about $100,000 a year. Her parents wanted to terminate her artificial hydration and nutrition. The case worked its way up to the Supreme Court. Missouri said that they couldn't. And in a 5-4 decision, which was the first ruling on the right to die, the court decided that the state did have a right to and an interest, and so they could define that right. And Missouri could stop the parents from withholding food and water, but they needed clear and convincing evidence that she would have wanted to die. And in this particular case, there was nothing written down, and so they couldn't go through with that. Now, Scalia concurred, and in a concurring opinion, that means the judge agrees with the outcome, but not necessarily the reasoning. And one of the things he pointed out was, one, he saw no distinction between refusing treatment and suicide, and he believed the state had an interest in preventing suicide. But he said the federal courts had no business in it, that it was purely a state interest, that there was not a constitutional right, but the state could create such a right. He said the Constitution has nothing to say about the subject. This court has no need to inject itself into every field of human activity where irrationality or oppression might occur. Interestingly, the dissent, which was Justice Brennan and Marshall, they just said it's nobody's business other than the person. So that was kind of the range of opinions on this issue. This one, Jaffe versus Redman, which was in 1996. And on your handouts, I have all these cases in the site. If you ever want to look them up, you can just Google, just put the site in. And the cases are really quite readable. This case I put in for Dr. Emmons and all the other psychiatrists in the room. This case involved an on-duty police officer who killed someone, and she spoke with a licensed clinical social worker after the incidents. The plaintiffs for the victim wanted the notes from what the officer said. The court, she asserted psychotherapist patient privilege. The court held that the notes were protected. Scalia dissented. He said, "The court today ignores this traditional judicial preference for the truth and ends up creating a privilege that is new, vast, and ill-defined." When is it, one must wonder, that the psychotherapist came to play such an indispensable role in the maintenance of the citizenry's mental health? For most of history, men and women have worked out their difficulties by talking to their parents, siblings, best friends, and bartenders, none of whom was awarded a privilege against testifying in court. Ask the average citizen, would your mental health be more significantly impaired by preventing you from seeing a psychotherapist or by preventing you from getting advice from your mom? I have little doubt what the answer would be. Yet there is no mother-child privilege. So you guys, don't get excited. Now, Bob, you're nodding your head like he was an evil man. This actually is good for physicians when it comes to wondering about privileges in mid-levels. Because what his real issue was that she was a licensed clinical social worker. And he said, she's a licensed clinical social worker. It's not clear that a degree in social work requires any training in psychotherapy. And that's what his real issue was, that it wasn't really like a trained psychologist or psychiatrist. The next case where he certainly became famous for, as did Justice Roberts, was National Federation of Business versus Scalias. That's the first Obamacare case. And that's where Justice Roberts, one, decided it wasn't a valid exercise of the Commerce Clause. That was a good thing. But that the penalty is a tax. Therefore, under the Taxing and Spending Clause, Congress could enact this law. During oral argument, Justice Scalia said, could you define the market? Everybody has to buy food sooner or later. So you could define the market as food. Therefore, everybody is in the market, and you can make people buy broccoli. That's one of the more famous things, and many people now still quote that. And with regard to the Commerce Clause, he says, but if every person who comes within Commerce Clause power of Congress to regulate by the simple reason that he will one day engage in commerce, the idea of a limited government power is at an end. And this is what he constantly tried to drum into people. You just can't have the government take over everything. And again, talking about that it's for Congress to make laws. The court today decides to save a statute Congress did not write. The court regards its strained statutory interpretation as judicial modesty. It is not. It amounts instead to a vast judicial overreaching. It creates a debilitated, inoperable version of healthcare regulation that Congress did not enact and the public does not expect. And in his King versus Burwell dissent, that was the next big Obamacare case, he said, we should start calling this law SCOTUS care. And this is exactly how I felt about so many things. Now, one issue that I want to bring up is his love for the First Amendment and freedom and how principled he was in that regard. In a case, United States v. Eichmann, which was about the Flag Protection Act that prevented flag burning, he sided with Justice Brennan, Marshall, Kennedy, and Blackmun. So all the liberal judges, Kennedy the on-the-fence one. And he said that prosecution for burning a flag in violation of the act is inconsistent with the First Amendment. And then later, when interviewed about it, he said, if it were up to me, I'd put in jail every sandal-wearing, scruffy-bearded weirdo who burns the American flag, but I'm not king. And this shows how principled he actually was. Now, this case I'll mention mainly because I love the name. It's one of my favorite Supreme Court names. The Church of the Lukumi Babalu Aye versus the City of Hialeah. And what this case is about, this is about First Amendment religious liberty. The Santeria Church bought some property in Hialeah. The City Council was upset about this because Santeria religion does animal sacrifice with chickens. And so they had an emergency interpretation of their animal protection statute that said you couldn't kill chickens, even in religious rituals. The Supreme Court reversed the lower court that found that City Council rule was okay. And they noted a non-neutral motive of the law. Again, Justice Scalia concurred. He agreed with the outcome, but he said, the First Amendment does not refer to the purposes for which legislators enact laws, but to the effects of the laws enacted. And the First Amendment says, Congress shall make no law prohibiting the free exercise of religion. This does not put us in the business of invalidating laws by reasons of the evil motives of their authors. Had the ordinances here been passed with no motive on the part of any councilman, except the ardent desire to prevent cruelty to animals, they would nonetheless be invalid. Again, the statute says what it means. Now, I won't go a lot into this, but Justice Scalia is also the one who wrote that the Second Amendment protects the individual right to possess a firearm unconnected with service in the militia. He said, undoubtedly some think that the Second Amendment is outmoded in a society where our standing army is the pride of a nation and where gun violence is a serious problem. That perhaps is debatable. What is not debatable is that it is not the role of this court to pronounce the Second Amendment extinct. And that ended up being a huge case, and the follow-up case decided, so it was both for federal and states that people had the right to own guns. Now, he was a stickler for privacy, and again, most of these cases, he had Justice Ginsburg, Kagan, Sotomayor were deciders with him against the rest of the court. National Treasury Employers Union versus Von Raab was a case of Customs Service employees that were required to have a urinalysis if they wanted to carry a gun or work with classified information. And the court had held that the test was reasonable, despite not having probable cause or individualized suspicion. So Scalia dissented, and this was with Justice Marshall and Brennan. He said, the government asserts it can demand that employers perform an excretory function traditionally shielded by great privacy, while a monitor of the same sex remains close at hand to listen for normal sounds, and that the excretion thus produced turned over to the government for chemical analysis. In my view, the Customs Service rules are a kind of immolation of privacy and human dignity in symbolic opposition to drug use. Moreover, there's no reason why this super protection against harms arising from drug use must be limited to public employees, a law requiring similar testing of private citizens who use dangerous instruments, such as guns or cars, or who have access to classified information, would also be constitutional. Sound familiar? This is when we've heard all these talks and talk about these health information databases and whatnot. Harken back to this opinion. Another one that, again, he is very strong on the Fourth Amendment, search and seizure. And again, he's joined by Ginsburg, Sotomayor, and Kagan. This was not needing a warrant for a drug-sniffing dog outside someone's house. And Scalia said, when it comes to the Fourth Amendment, the home is first among equals. At the amendment's very core is the right of a man to retreat in his own home and be free from unreasonable government intrusion. This would be of little practical value if the state's agents could stand in a home's porch or side garden and trawl for evidence with impunity. Again, this is so reminiscent of these folks storming into doctors' offices with no probable cause. The next one, again, a Fourth Amendment case, which normally we associate this with criminals, but frankly, these days I feel like we've all become criminals, so we need to be aware of these cases. This case, Marilyn v. King, a very recent one, the court again held 5-4, that it was okay for the police to take DNA from an arrestee, and they decided that taking DNA was just like fingerprinting and photographing, and it was a routine booking procedure. Again, Scalia dissented, and this is with Ginsburg, Sotomayor, and Kagan. Again, he's not with the conservative core here. He's such a stickler for privacy. We're told that privacy-related concerns in the search of a home are weighty enough that the search may require a warrant. But why are the privacy-related concerns not also weighty when an intrusion into the body is at stake? The court repeatedly says that DNA testing and entry into a national DNA registry will not befall thee and me, dear reader, but only those arrested for serious offenses. If one believes that DNA will identify someone arrested for assault, he must believe that it will identify someone arrested for a traffic offense. Make no mistake about it. As an entirely predictable consequence of today's decision, your DNA can be taken and entered into a national DNA database if you are ever arrested, rightly or wrongly, and for whatever reason. Again, sound familiar? So, one of the things we've seen from these cases is that if you stick to principle, you might not always be with the justices that you're traditionally associated with. And we all always assume that conservative, conservative, conservative. Well, as you can see from these cases when it comes to privacy, search and seizure, that Justice Scalia was always with the liberals. He just treasured it so highly. And one of the things that came out of the way he lived and who were his friends, it was pretty well known, he and Justice Ginsburg were very good friends. And one of the things when justices are on the high court, there's not too many people they can be friends with because they can't talk about anything. And so they do find friendships among the court. But this is a picture of Scalia and Ginsburg, and they were posing dressed up as the cast of one of their favorite operas. And what we kind of learn from their friendship is that we can be civil when we have disagreements, and I hope we all are, and it also helps you win an argument if you can stay civil. In U.S. v. Windsor, one of the gay marriage cases, he noted, in the majority's telling, this story is black and white. Hate your neighbor or come along with us. The truth is more complicated. It's hard to admit that one's political opponents are not monsters. One of the things that we have to look out for, of course, is with the next president that we find a justice like this who does want to look at what the Constitution says. It says that the government powers are very limited and stick to their principles no matter what their personal belief is about an issue. Judges are not there to make laws. Here is what Justice Scalia said in a actually it was his last dissent. Today's decree is that my ruler and the ruler of 320 million Americans, coast to coast, is a majority of the 9 lawyers on the Supreme Court. This practice of constitutional revision by an unelected committee of 9, always accompanied by extravagant praise of liberty, robs the people of the most important liberty they asserted in the Declaration of Independence and won in the Revolution of 1776, the freedom to govern themselves. So we take his words, and certainly here at AAPS, we do try to live by them. We want the freedom to govern ourselves, govern our own practice. And I want you to remember these cases when folks come barreling in. And just as Andy had mentioned the other day, you can say no. These cases tell you you can say no. And most people allow themselves to be bullied by the government. Justice Scalia didn't, and we're not going to either. Thank you.